Now, in this program, any resemblance between the people you see on the screen and real living people is purely intentional. Because, in fact, they are real, and it's our pleasure to catch them in the act of being themselves.
Here with you today. We got a banger of a video coming to us from Wildman Audits. He sent this to me, told me to check it out, share it, get some more eyes on it, and I love it, man. It's a video of Wildman in the courtroom addressing some issues that he's been having. And, you know, this is a trend that I wish would catch on. Americans fighting the government in court and just taking it to them, you know? I want to thank Wildman Audits for, first and foremost, standing up for his rights. Second, for, you know, getting the video of this interaction so everybody else could see it. And for just being an all-around cool dude. So head on over. He's got about 4,000 subs. Sub him up. Let him know the Major sent you. And tell him thanks. And we look forward to more work from this young man as he progresses. So thanks again for watching, guys. And as always, be on the lookout for the next video, because as always, there's always going to be a next video. So
my name is Cody Henderson. I am the appellant, and I was the respondent to a civil protection order, which is the underlying case that is being appealed here. And the civil protection order was filed by a police officer who erroneously asserted that I had caused him and his family some type of threat. I don't know the specifics beyond that.
Let me just ask you, Mr. Henderson, in your brief, you stated that when they tried to serve you with the copy of the protection order, you said you declined to contract with the officers. What do you mean by contract?
I mean that I have the fundamental constitutional right to contract, to enter contracts, and to not enter contracts. So that means whenever someone comes up to enter an agreement with me to talk, that is a contractual agreement to speak to each other. And I meant that I did not choose to contract with those officers. I did not choose to speak to them in any effect of the matter. And I think the key difference here, because a lot of people look at this situation and they think of it in a criminal context. In a criminal context, it would be different. The officers obviously would have probable cause of a crime being committed, which would allow them to detain me and to violate or temporarily put my Fourth Amendment right on hold while they're detaining me for the crime. Now, in this case, it's completely different because this is a civil protection order, so it must follow Ohio civil rules of procedure. Clearly, in my brief, I lay out the civil rules of procedure that apply, which is Rule 4.1, capital B2, lowercase a and lowercase b. Those are two separate subsections. Lowercase a states that the sheriffs do have the ability to come up and serve someone with civil process. But section lowercase b states if that service is refused, which I did, I refused it, then they must follow a whole different procedure which requires them by law to send it certified mail, which they did not do. Instead, they arrested me for refusing it, which is not okay, and it's a violation of my constitutional rights, and a 1983 lawsuit is going to come from that, but that's a separate issue. The issue here is my constitutional rights were clearly violated by the people who claim they served me according to law. They did not serve me according to law.
Well,
I just
the
explained
trial court's record indicates that you're served. I know you're saying you weren't, but the trial court's
and
record. Let me finish. The trial court's record reflects that you were served, and there was a hearing where you could have raised the issues that you raise now on appeal, but you didn't appear for that hearing.
I didn't get notice of the hearing.
But you didn't raise that in your motion for new trial.
I did raise it in my motion for new trial. I raised the fact that I wasn't served according to law in my motion for new trial. So
with the civil protection order, not the notice of the June 17th hearing.
I didn't get notice of the June 17th hearing, which came with the civil protection order. The civil protection order itself had a hearing date all attached with it, and everything with it. I didn't receive any of that paperwork.
That hearing was
And
continued and a new
I
hearing
raised my
was
motion for new
scheduled.
trial. I raised the fact that I did not receive any mail from them. They sent the mail to the wrong address, and I didn't receive any of those notices. Furthermore, there's an affidavit that proves that and asserts that, and there's no evidence that can rebuttal it. Further than that, these officers are already caught on body camera, violating my constitutional rights and never serving me that paper. This same sheriff office has a body camera policy to have body cameras on when they're interacting with the public and doing business. So if they did serve me that, they would have to have recollection of it on body camera. Does not exist because they never served it to me. They arrested me, took me to jail, strapped me to a restraint chair, and tortured me because they think that that's the proper way to punish someone for not obeying their orders in relation to a civil summons, which is not okay, and that's not the proper procedure to law. Furthermore, I'll let the other side go, and I'll come back.
Okay. Any other questions?
No.
Excuse me. Good morning, may it please the court. Mr. Henderson, my name is Ashley Hetzel on behalf of Appellee William Jason Lawless. What's required by law for a civil protection order is the notice and the opportunity to be heard. Mr. Henderson received notice of the protection order and the hearing, and he had an opportunity to be heard at that hearing. That's what the trial court had in front of it, that the sheriff's deputies properly served Mr. Henderson with the protection order and the notice. At the hearing, Mr. Henderson, for whatever reason, chose not to appear. It wasn't until after the hearing had been concluded that Mr. Henderson called the court to let them know that he was running late to the hearing. Like I mentioned in our brief and just now, the hearing had already been concluded.
Can we actually consider the trial court's statement that he called after the hearing?
Objection hearsay.
This isn't a trial. This is just, on appeal, it's just pure arguments. So she can make any presentation, include hearsay if she wants to. That's okay here.
Okay, hearsay is part of evidence.
Yeah.
I believe that the trial court was in the best position, and it's within their discretion to consider evidence. And so, based on what was in front of the trial
Well,
court.
but my question is, it seems that the evidence you're talking about was offered by the trial court itself in its decision. Is that an appropriate role for the trial court to play in putting that statement on the record?
We believe so. We believe that the trial court's in the best position to consider that evidence and the credibility. And it was also in front of the trial court that the service had been perfected on Mr. Henderson, and that he had notice of the hearing and an opportunity to be heard at that hearing.
Okay. How do you respond to his argument under the B subsection that the officers, he says, didn't follow the correct procedure?
Mr. Henderson raised those arguments in his motion for a new trial that was filed with the trial court. And so my response is that the trial court, it's within its sound discretion to consider those, and the trial court chose to deny the motion for a new trial.
So what is your position as to what the police officers, how they served him? He's claiming that he refused and there's another procedure that wasn't followed.
My response to that is that the sheriff's deputies had returned the service to the trial court as being perfected. And that's what the trial court considered, is that the service was perfected.
Okay.
So you're saying essentially that there was a document in front of the court that said it was properly served. He's saying on appeal that it wasn't properly served.
That's
But
correct.
are you saying that's not in the record?
No, it's in the trial docket, number 8, is that the notice to serve was returned and executed on Mr. Henderson on May 21st, 2024 by the sheriff's deputies.
And then the burden shifts if somebody wants to challenge service. The person who's challenging the service would have to bring forth evidence that they weren't properly served.
Correct.
Okay.
finally, I would just like to make the last point, because Mr. Henderson did begin to speak as to the merits of the civil protection order. And I would just like to point out that his opportunity to appeal the merits was filed, if at all, 2 days late. So he has foreclosed on appealing the merits of the civil protection order. And if the court has no further questions. He would-
No.
Thank you, Your Honor.
All right, first of all, I did rebut the notice from the sheriffs that it was served on me, and I did that in my motion for new trial, because I didn't get the opportunity of a hearing, as I should, and I think that my Fifth Amendment right and 14th Amendment right to due process has been clearly egregiously violated here, because I have not gotten the right to a hearing, and I proved that in the body camera footage that I included and attached to my motion to new trial. Which
You have to understand, when you motion for new trial is not challenging the service. When you're motion for new trial, you're saying you just want the opportunity to be heard, that you didn't commit these acts. So it's almost acknowledging that you got served.
No, my motion for new trial was me motioning for new trial based on the fact that the order was issued contrary to law, and I was just exerting my remedies as appellate courts generally recommend for people to do in the trial courts, is to exert their remedies before bringing something before the appellate court. So I did that out of honor of you guys. I tried to file this motion for new trial to have it dealt with on the trial court level, hoping that the judge would realize that there was an egregious violation made and there was a mistake made, and that he would give me the actual right to a hearing that I, as an American, have the right to. But unfortunately, he didn't do that. Instead, what he did is he responded with an entry that says that the court finds that the respondent was served according to law, despite his efforts to thwart said service. This is hostile language used against me. I did not thwart said service. I exercised my constitutional rights. And to twist the words and act as if I am thwarting something by exercising my fundamental rights is egregious, and not only egregious, it's hostile towards me and prejudiced me massively. Furthermore, he goes on, and the rest of his reliance in the entire order is based on hearsay that he heard apparently from his clerk between a phone call that I had personally with his clerk. And with his clerk, this phone call did not say that. What I said is, I don't know when there's a hearing, but I heard from my current attorney there's a hearing in this case. Can you tell me when it is? She said, actually, it just happened 30 minutes ago. I said, can you get me together every record in the case? I'm going to pick it up in an hour. Drove up there immediately, picked it up, and filed this motion for new trial as quickly as I possibly humanly could, within days. And I'm not an attorney, by the way. Okay? So the amount of work that I put into this is ridiculous. And really what I'm appealing here is I'm appealing this entry from Judge Bender here from the trial court that is completely based off hearsay. That's against the rules of evidence, first and foremost, for the judge to enter hearsay against me. For two, the judge entering his own evidence is the practicing of law, which is a violation of Ohio Judicial Rule of Conduct 3.1, thou shalt not practice law. You can't practice law from the bench. That's a rule that goes back all the way to the Magna Carta. So we can take this back common law to the back of the beginning. But this is an egregious violation of my rights on multiple fronts, whether it goes to the sheriffs violating my constitutional rights when they didn't let me leave and they didn't let me refuse the contract and send it certified mail according to law. That's the first egregion of my constitutional rights. Number two is the judge acted with clearly contrary to the law because he introduced his own evidence against me, which is biased and prejudiced me directly. And he based his whole finding off of this thwart said service, this hostile language that he's using against me without any case law, without any citation to evidence. And as I said, I've submitted video that proves that I wasn't served properly. There's obviously prejudice by the judge. It's ridiculous what is in this order right here. I can't believe that somebody that went to law school wrote this, because my writings are far more intelligent and artful than to say someone thwarted said service by exercising their constitutional rights. Never should I be seen as being thwarting a service by exercising my constitutional rights. The Constitution is the supreme law of the land, and if we don't have constitutional rights, we don't have law, period. So, furthermore, I would like to cite Breyers versus United States. It is the duty of the courts to be watchful for the constitutional rights of the citizens. And that's cited in my brief. And it's also been reaffirmed in Boyd. So Boyd versus United States and Byers versus United States emphasize the same exact sentiment, that it's the duty of the courts, the absolute duty of the courts, to be watchful for the constitutional rights of the citizens and against any stealthy encroachments thereof. This civil protection order, the order from Judge Bender, the way the trial court treated me and the way that I've not been given the opportunity of fair service is an absolute stealthy encroachment on my constitutional rights, on Ohio constitutional rights, my Fourth Amendment, my Fifth Amendment, my 14th Amendment, and furthermore, my freedom of locomotion when these sheriffs grab me up for no reason. So I think that I have every right in law to assert that I have the right to have this trial or have this case reversed and remanded back to the trial court, where I can actually get the opportunity to address my accuser, address all of this, address this order from the judge that is based off hearsay, and actually go through this according to law, through the proper techniques and the proper citations that has been founded through common law and has been supported ever since. And so I'm a big activist of the Constitution, and that's why I've been targeted here. And that's why this is all happening, is because I'm suing her client for $2.3 million for violating my constitutional rights. And the Judge Bender, obviously doesn't like that, if you can tell by his order, that uses hostile language against me, and that further uses hearsay as the only basis to substantiate the claims of why I don't deserve a new trial. Furthermore, I've clearly proven in my motion for new trial that for every other reason, I do deserve a new trial. So for those reasons listed and the reasons in my appellant brief, I'm kindly and respectfully asking this court to stand for constitutional rights, to stand against stealthy encroachments as the Supreme Court has commanded, and to stand on behalf of the constitutional rights of the citizens and allow this to go through the court through the proper procedures. I'm not asking for a freebie here. It's still got to be remanded. I've still got to fight my way through this. I'm not asking for you guys to side with me completely. I'm just asking for an opportunity to fight this case. That's it. Thank you.
All right, any other questions?
No.
I have none.
All right, thank you. All right, appreciate both of you coming in here this morning. We'll take the matter under advisement, and then we'll render our decision.
It's a wild man arguing his first appeal. What do you expect? Was your boy cooking? Post your comments below. Subscribe, like, comment, share.